The U.S. SEC challenges the 2023 verdict in a last-minute opening brief against Ripple. The long-running dispute between Ripple, a blockchain-based cross-border remittance provider, and the U.S. Securities and Exchange Commission is anticipated to continue. However, Stuart Alderoty, the chief legal officer at Ripple, has called the matter noise and believes it will be dropped in the administration that succeeds this one. In an attempt to expedite its legal battle against the blockchain-based digital payment network Ripple, the U.S. Securities and Exchange Commission has filed its opening brief deadline. The United States Securities and Exchange Commission, DISC, versus Ripple and its executive brief must be submitted by January 15, 2025 at the latest, according to an order issued by the U.S. Court of Appeals for the Second Circuit in October of last year. The appeal will be denied if this deadline is missed. The United States Securities and Exchange Commission is challenging Judge Annalisa Torres's ruling from July 13, 2023, according to court filings. The court documents reveal that the regulator plans to challenge a part of the order issued by New York Judge Annalisa Torres on July 13, 2023, stating that XRP tokens were classified differently when they were distributed to institutional investors and average investors. The financial watchdog stressed that Torres's conclusion that gains cannot be anticipated until investors consciously purchase from the issuer is in conflict with the uncontested facts and the applicable law. The Securities and Exchange Commission, or SEC, emphasized that the court's decision breaches basic securities laws and causes an unmanageable gap between investors' expectations. The SEC argues that the ruling directly contradicts the Howey test, a process used to decide whether an asset qualifies as a security. According to the paper, the regulatory authority continued to accuse Ripple, Christian Larson, its co-founder, and Brad Garlinghouse, the company's CEO, of breaking the rules pertaining to the selling of XRP tokens to institutional and retail investors. The commission also criticized the decision for making a distinction between institutional and individual investors. According to the panel, the goal of Ripple's extensive marketing campaigns was to raise the price of XRP. Stuart Alderoty, the chief legal officer at Ripple, said in an X piece that the regulator's last-minute action was expected. The legal expert claims that the current court petition is an example of the initial arguments that failed in the previous court proceedings. Alderoty expressed his belief that the next administration, headed by President-elect Donald Trump, will ultimately give up on the long-running problem, calling the financial watchdog's legal action nothing more than gibberish. Furthermore, the legal experts stressed that Ripple would thrive as a result of the impending start of a new era of regulation that will support the cryptocurrency industry. When asked about the SEC's legal action, Brad Garlinghouse, the CEO of Ripple, called it crazy. He criticized the regulator for doing the same thing again and over again while expecting different results. The United States Securities and Exchange Commission has previously been accused by members of the Ripple community of trying to delay the settlement of its legal dispute with the company. Users claim that the regulator intentionally filed at the last minute to give the defendants and the whole Bitcoin community a great deal of annoyance. Despite the legal issues that have emerged, investors are optimistic about the future outlook for XRP and the cryptocurrency sector overall this year. In contrast to the top 10 most valuable cryptocurrencies by market value, XRP has gained 15%. According to data from the cryptocurrency data aggregator CoinMarketCap, XRP has gained almost 8% in the last day, for a total gain of 28.77% during the last 7 days. The digital asset is currently for sale at $3.02 at retail, with a market valuation of $173.7 billion and a 24-hour trading volume of $22.7 billion. Right now, the cryptocurrency is ranked third among the best digital assets available. In the ongoing lawsuit it is pursuing against Ripple, the U.S. Securities and Exchange Commission has formally filed an appeal. The SEC is trying to classify XRP, a cryptocurrency, as a security. In a previous ruling, the U.S. District Court for the Southern District concluded that some XRP sales to individual consumers did not contravene securities regulations. In a brief filed on Wednesday, the Securities and Exchange Commission stated that it disagreed with this decision. The appeal essentially contests the district court's differentiation between the company's regular and institutional investors. According to the Securities and Exchange Commission, the district court reasoned that since Ripple implied that its actions would raise the price of XRP, big investors could reasonably have anticipated rewards from the work of others. The Securities and Exchange Commission, or SEC, argued that the district court's distinction between the goals of institutional and retail investors was irreconcilable with the objective investor criterion outlined in the Howey test. Furthermore, they said that it goes against a fundamental principle of federal securities laws, which holds that less sophisticated investors can be protected just as well as more sophisticated ones. The district court erred in concluding that regular investors did not have the same expectations. Nevertheless, because they bought XRP via cryptocurrency asset trading platforms, they were unable to determine if the vendor was Ripple, a Ripple affiliate, or another party. The Securities and Exchange Commission, or SEC, is attempting to reverse the court's ruling in favor of Ripple by claiming that all trades of XRP are unregistered securities. If they win, you can anticipate that the case will be returned to the trial court. There have been rumors that the Trump administration's Securities and Exchange Commission, or SEC, may alter its stance on cryptocurrency regulation. There is a chance that enforcement actions will be paused, which could lead to speedier settlements and a shift away from the idea of enforcement regulation, according to sources. It is expected that the upcoming administration will treat the Bitcoin industry with greater respect and clarity. This is because Gary Gensler, the current secretary chair, is expected to resign the following week. As the deadline for the SEC's appeal approaches, the whole cryptocurrency sector is closely monitoring the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission, or SEC. In honor of Arthur Brito, one of the co-founders of the XRP ledger, there is a group called Brito. Brito claims that the SEC has until January 15, 2025, to file its appeal brief in the matter of Ripple. Brito asked on Twitter about the possibility of expulsion if the Securities and Exchange Commission fails to meet this deadline. In response to Brito's request, Mark Fagel, a former Securities and Exchange Commission lawyer, stated that it is improbable that an appeal would be denied because of a missed deadline. In response to the first query, Brito asked if it is typical for government organizations like the SEC to wait until the last minute to file anything.